5 seconds to go. Start. It will be relevant to refer to the observations of the Constitution Bench in the said case, which read thus: there can be no controversy that Section 13A, introduced by Section 5 of the Second Amendment Act, deals only with the appellant. In fact, the stand taken on behalf of the respondents in the counter affidavit filed before the High Court was to the effect that the legislature had chosen to treat the Vice Chancellor holding office at the time of the commencement of the Second Amendment Act as a class by himself, and with a view to enable the Chancellor to make fresh appointments. Section 13A of the Act was enacted. Therefore, it is clear that Section 13A applies only to the appellant, though no doubt it has been stated on behalf of the respondents that similar provisions were incorporated at about the same time in two other acts relating to two other universities, viz., the Andhra University and the Shri Venkateshwara University, and though this circumstance has also been taken into account by the learned judges of the High Court, in our opinion, those provisions have no bearing in considering the attack levelled by the appellant on Section 13A of the Act. This is a clear case where the statute itself directs its provisions by enacting Section 13A against one individual, viz., the appellant, and before it can be sustained as valid, this court must be satisfied that there is a reasonable basis for grouping the appellant as a class by himself, and that such reasonable basis must appear either in the statute itself or must be deducible from other surrounding circumstances. According to learned counsel for the appellant, all vice chancellors of the Osmania University come under one group and can be classified only as one unit, and there is absolutely no justification for grouping the appellant under one class and the vice chancellors to be appointed in future under a separate class. In any event, it is also urged that the said classification has no relation or nexus to the object of the enactment. In our view, the Vice Chancellor who is appointed under the Act, or the Vice Chancellor who was holding that post on the date of the commencement of the Second Amendment Act, form one single group or class. Even assuming that the classification of these two types of persons as coming under two different groups can be made, nevertheless, it is essential that such a classification must be founded on an intelligible differentia which distinguishes the appellant from the Vice Chancellor appointed under the Act. We are not able to find any such intelligible differentia on the basis of which the classification can be justified. For the above reasons, we accept the contentions of the learned counsel for the appellant and hold that Section 5 of the Second Amendment Act, Act 11 of 1966, introducing Section 13A in the Act, is discriminatory and violative of Article 14 of the Constitution, and as such has to be struck down as unconstitutional. The result is that the appeal is allowed and the appellant will be entitled to his costs in the appeal payable by the respondents here and in the High Court. It can thus be seen that the Constitution Bench found that Section 13A was applied only to the appellant therein. The Court further found that the Vice Chancellor who was appointed under the said Act, or the Vice Chancellor who was holding that post on the date of the commencement of the Second Amendment Act, formed one single group or class. The court found that though the classification of these two types of persons as coming under two different groups could be made, however, the same could not be made unless the classification was founded on an intelligible differentia which distinguished the appellant from the vice chancellor appointed under the Act. The court found that before upholding an enactment applicable to one individual, this court must be satisfied that there is a reasonable basis for grouping such an individual as a class by himself, and that such reasonable basis must appear either in the statute itself or must be deducible from other surrounding circumstances. The court found that there was no such intelligible differentia on the basis of which such classification could be justified. In the case of S.P. Mittal versus Union of India and others, the Constitution Bench of this court was considering the provisions of Oroville Emergency Provisions Act 1980. In the said case also, an argument was advanced that a legislation singling out Sri Aurobindo Society amounted to hostile treatment. Dealing with the said argument, speaking for the majority, R.B. Mishra judge observed thus: it was further contended by Mr. Venu Gopal that if the management of the institution had been taken over by the government on the ground of mismanagement, there could be other institutions where similar situation might be prevailing. There should have been a general legislation rather than singling out Sri Aurobindo Society for hostile treatment. The argument cannot be accepted for two reasons. Firstly, because it has not been pointed out which were the other institutions where similar situations were prevailing. Besides, there is a uniqueness with this institution inasmuch as the government is also involved. Even a single institution may be taken as a class. The situation prevailing in the Oroville had converted the dream of the mother into a nightmare. There had arisen acute law and order situation in the Oroville. Numerous cases were pending against various foreigners. The funds meant for the Oroville had been diverted towards other purposes, and the atmosphere was getting out of hand. In the circumstances, the government intervened and promulgated the ordinance, and later on substituted it by the impugned enactment. It cannot be said that it is violative of Article 14 on that account. We are afraid the argument has no substance. Obviously, there were serious irregularities in the management of the said society, as has been pointed out in the earlier part of the judgment. There has been misutilization of funds and their diversion to other purposes. This is evident from the audit report. There was no material change in the situation on the date of the impugned ordinance or the act. Rather, the situation had grown from bad to worse, and the sordid situation prevailing in the Oroville, so pointed out by the parties, fully justified the promulgation of the ordinance and the passing of the enactment. Of course, each party tried to apportion the blame on the other. Whosoever be responsible, the fact remains that the prevailing situation in the Oroville was far from satisfactory. The amount donated for the construction of the cultural township, Oroville and other institutions was to the tune of rupees 3 crores. It was the responsibility of the government to see that the amount was not misutilized and the management was properly carried out. So, the basis of the argument that the facts, as pointed out in the preamble, were nonest is not correct. No doubt that the court held that even a single institution may be taken as a class In the facts of the said case, the court found that from the preamble of the impugned enactment itself, it was clear that there were serious irregularities in the management of the society. Stop.